જયરામભાઈ, જયરામભાઈ, ધર્મેન્દ્ર ખટી, ધર્મેન્દ્ર ખટી, ધર્મેન્દ્ર ખટી, વકીલ શ્રી કે પ્રજાપતિ, વકીલ શ્રી કે પ્રજાપતિ, વકીલ શ્રી વિધિ ગુપ્તા, વકીલ શ્રી વિધિ ગુપ્તા, બે આરોપી છે. જયરામ અને ખટી બે છે. પેલામાં બે નંબર આવે છે વિષયમાં ધર્મેન્દ્ર આપે છે. નિખિલેશ યસ પછી એમાં સર ફરિયાદીને સમન્સ કરે તો એના મરણના સર્ટિફિકેટ સાથે ગુજરી ગયા છે. જી સર ગુજરી ગયા છે. એ સાહેબના ફાધર હતા ઇન્ચાર્જના 99% સાહેબ સમાધાન છે. 10 મિનિટ એમના વકીલની રાહ જોઈ હા બંને કેસ પર સાહેબ સિરિયલ નંબર 9 એનો ક્રોસ છે. ફરિયાદી તો એની ફરિયાદી એમાં ફરિયાદી આ જયરામ ઓકે સમન્સ કરે તો 9 ઓકે આરોપી હાજર છે. આરોપી હાજર सेशन केस 261/20 सुधीर कुमार वकील श्री एक शेख फर्स्ट सुधीर कुमार 31/7 सेशन केस 10/21 आरोपी नंबर 1 અને 2 જાતે આપણે એક કે બે છે ત્રણ બેટ છે રાજન મહાદેવન યાદવ હનુમાન ગણપત ચૌહાણ અબ્દુલ વાહિદ શેખ અબ્બાસભાઈ ગોરા અનિલભાઈ દિયા 4 પંચો છે ને સાહેબ છે એના સમજ ડીસીપી મારફતે કર્યા પરત લખીને લઈ ગયા હોય જી સર 31/7 ઓકે સમજ પરત ન્યુ વેટ કરો सेशन केस 49/21 સાથે 50/21 શશીભાઈ પોલીસ કમ્પ્લેન્ટ છે ડ્રાઇવિંગ છે એક્સપીરિયન્સ ડ્રગ્સ યુઝ સેક્શન છે યસ જોશ મકોને બોલાય છે તેમાં ડી માટે છે ડી માટે છે ડી માટે બીજી કઈ છે 49 જોડે 4 ને 5 50/21 એ બી છે ઓકે એમાં ડી માટે જી સર એમની બંને ઓફેન્સ તો સરખા ના વેટ કરું सेशन केस 91/21 प्रमोद सिंह राठौर वकील श्री टीटी तिवारी लास्ट टाइम मारते फाइल कर सूट पहला कि आगे आवे तो आरोपी आया છે નથી આયા 80/22 सेशन केस 80/22 अल्ताफ लोहिया यास्मीन शेख 3 થી 13 અને 15 થી 22 ની નામદાર હાઈકોર્ટે પરમિટ એક્સેપ્શન 3 થી 13 અને 15 થી 22 તો તમને એનએસ પટેલ બે મામલું પરમિટ એક્સેપ્શન એક માં ગયું છે 3 થી 13 અને 15 થી 22 15 થી 22 અને 14 એક્ઝામ્સ હતા 15 થી 22
છેલ્લું બધું પછી કોણ બાકી છે?
બે નંબર બાકી ગયા. લાસ્ટ ટાઈમ
આવે
બે ના હતા પણ મોડે થયા. એમાં ટીમ માટે સર યાદી કરી.
બોલો એપીપી નું બોલો.
કેવું છે? 3 થી 13 અને 15 થી 12. આજે રહેવાનું.
ગુડ. યસ.
સ્ટેશન કેસ 273/22. સારું. સેક્રેટરી મુંબઈમાં. મોહમ્મદ અબ્દુલ રઝાક
તો મુંબઈ વાળા આપણે કીધું તો જોઈન કરજો.
જી સર.
જોઈન કરજો. તમારે અમુક જુબાની કુછ બાકી લાગે છે. બે ત્રણ શાયદી નથી. જોઈ લો. જોઈ લેજો તમે. એવું તો બને. મુંબઈ થી કનેક્ટ થયા છે.
ના નથી.
આપણને ગઈ વખત સૂચના આપી હતી
હા, last
મોર્નિંગમાં કનેક્ટ કરજો.
11 વાગે.
વેટ કરો. હા
સેશન્સ કેસ 583/23. ગૌરાંગભાઈ દાતણિયા. સચિન દાતણિયા.
એક નંબર છે.
એક નંબર છે. બે નંબર છે. અશ્વિનભાઈ દાતણિયા. 3 નંબર છે. આકાશ દાતણિયા. ચાર નંબર છે. ધનરાજભાઈ 5 નંબર છે. રજીતભાઈ 4 નંબર. કૈલાસબેન દાતણિયા.
3 જણા નથી.
1, 3, 4 અને 7 વકીલ માટે રાઈટ.
1, 3.
1, 3, 4.
ઓકે તમે આવવાનો છો એમાં?
1, 3, 4 ને 5. હા, 1, 3, 4, 7. 1, 3, 4, 7.
સાથે
બીજાની આઈડીટી પણ એમાં આવો વધારે છે.
કયો બીજાનો એડવોકેટ છે કોઈ એમાં શેક લાગે છે.
સર ડોક્ટર
1, 3, 4
સમજ
હા એનું વીપી આવી જાય ને એક્ઝામ્પશન નહીં આવે. સચિન ગૌરાંગ દાતણિયા આવ્યા છે.
ગૌરાંગ દાતણિયા, આકાશ દાતણિયા અને કૈલાસભાઈ દાતણિયા.
વેટ કરો.
એનો ક્રોસ છે. ગુલાબભાઈ દાતણિયા.
ક્રોસ છે ને?
નરેન્દ્રભાઈ દાતણિયા. અંકિત દાતણિયા. સંદીપભાઈ
ને હિતેશ
અને હિતેશ.
એ પણ છે.
એમાં ટીમ આવું.
ડી માટે જ છે. ચાર્જ થઈ ગયું
ના બાકી.
583/23 માં શું છે?
583 માં ડોક્ટરની ટીમ બાકી હતું. 4 નંબર એટલે વકીલ માટેનું હતું.
આજે જોયું એ પતી ગયું ને પણ તો ડોક્ટર સમજ કાઢી આમાં ના એક્ઝામ્પશન લઈ લઈએ. સમન્સ ડેટ 2 માં ડેટ આપી દઈએ. ઓલામાં ડી આવ્યું છે. રજૂ કરો જલ્દી. 25 ની મેટર છે. ડી બાકી છે.
તમારી 1, 4 અને 7 બાકી.
14/8 ડોક્ટર સમજ કરી નાખ્યું. કે 14/8 જે ના આવ્યો એમને હાજી ખબર છે.
વ્યાસ સાહેબ ના છે. 14/8 वकील श्री J.R. शाह,
वकील श्री J.R. शाह,
वकील श्री D.K. सरोज,
वकील श्री D.K. सरोज,
वकील श्री H.P. शाह,
वकील श्री H.P. शाह,
वकील श्री B.K. बशी,
वकील श्री B.K. बशी,
वकील श्री H.R. राघवानी,
वकील श्री H.R. राघवानी,
वकील श्री T.H. अग्रवाल,
वकील श्री T.H. अग्रवाल,
वकील श्री N.C. नायर,
वकील श्री N.C. नायर,
राजकुमार मोटुमल,
राजकुमार मोटुमल.
સૌથી છે ને
Even પણ એક round લીધેલું નતું.
યસ
Can the officer travel beyond the scope of the pleading for passing the decree or the order?
યસ ચલો આર્ગ્યુ કરો.
So far as the notice part is concerned, I will just pointed out that it has not been given. According to them, that the unauthorized occupier who has been given the premises by the tenant.
એ તો આર્ગ્યુ થઈ ગયું.
હું એ જ કહું છું, એ જ.
હમ
Then sir, can you just see the page 20? Please sir. જે આપણે હમણાં કહ્યું ને sir એને.
પ્લેન
Eviction application just like that civil law was the eviction application of plain thing.
યસ
It's a eviction application.
યસ
Page 2206.
બીજી છે ભાઈ
It has been marked 31 upon C, sir.
20
31 upon C.
31/0.
Is that PDJ with any?
હા
PDJ your files and.
યસ 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 એવિક્શન અરજી યસ
Just see the ground. There is no ground for the leases come to an end. And if at all, if they got the new ground, they could have amended the claim. Namely the eviction application.
યસ
So therefore, the lease has come to an end, it's not the ground. In the, and so therefore, there is no chance to the present appellant to deal with that ground.
યસ યસ
Then you wanna just kindly turn to page 44 of the same original file of the department,
યસ
which is my written statement dated 13th April 2010, and two paragraphs of that, paragraph 5 and paragraph 7.
$57 લાગે છે. રિપ્લાય તમારો 57C છે.
હા તો એ સાહેબ એ એમને પોતાના 57 58 એ રીતે કર્યું છે, પણ રનિંગ પેજ સાહેબ 44 જે પેન્સિલથી લખ્યું 44. અમારામાં એવી રીતે 44 લખેલી ફાઇલ આપો. તો એ સાહેબ
એ તમારો રિપ્લાય છે. આ રિપ્લાય છે તમારો.
હા સર પેલી ફાઇલ જોશો તો એમાં જ અલગ છે.
તમારો જવાબ છે જ આમાં. સામાવાળાની ફરિયાદની
No, no, ના નથી કહેતો મારો
તારો જવાબ.
જવાબ. But sir, there are two files from the department.
યસ યસ રિપ્લાય
That paragraph 5 in the first page.
યસ
ફરિયાદીને અરજીના પેરા 2 ના જવાબમાં જણાવ્યું કે સદસ્ય જે ભાડાના મહાસંઘે તથા ભાડે રાખ્યા અંગે જે વિધાન સાથે પછી ભાડા મહાસંઘ તકરાર નથી, પરંતુ સદર પેરામાં ફરિયાદી જે કરી આપણે જણાવ્યું તેના જવાબ કે કાયદે ભાડા તારીખ નામ આવી છે ભાડા આવી છે વધુ જો જાણીએ અચ્છા નથી કબૂલ નથી કરી હકીકત અમુક સમયે 4 રોજ બંધ કરેલી ફરિયાદીએ તેમના એડવોકેટ મારફત તેમને જે જવાબ અમે આપેલ એગ્રીમેન્ટ અગાઉથી તે મુજબ ઉપરની તારીખ 4/8/2007 રોજની ભાડા ચીઠી અને લીઝ એગ્રીમેન્ટ સદરુ ઈશ્વરભાઈ મોહનજી જીગર અંબિકા રેસો વકીલ પાર્ટનર તરીકે છે.
યસ
સદરુ રોજના ભાગીદારી કરારની નકલ પણ ફરિયાદીને મોકલી આપવામાં આવે છે. આમાં અમારે ભાડા ચૂકીને કોઈ ભંગ કરેલ નથી. Then sir, kindly just see the paragraph shown on this page at the bottom of the page. ફરિયાદીને અરજીના પેરા 4 ના જવાબમાં જણાવવાનું કે સદરૂપે છે. ફરિયાદી જે વિધાનો નાખશે તે સાચા નથી કરતા નથી. સદરૂપે જે જણાવે તે મિલકતનો કબજો મેળવવા માટે તારીખના રોજ નોટિસ આપે, ફરિયાદીને જવાબ આપે. અને પછી સર છેલ્લી 4 લાઈન
Yes.
again વર્કિંગ થયું જણાવે છે. ત્યારબાદ ફરિયાદી 5/5/2009 ના રોજ નો સામાન્ય પત્ર લખીને તેનો જવાબ મળે 18/5/2009 ના રોજ આપે છે. અને તે જવાબની સાથે તારીખ 1/4 ભરી રિલીઝ કરી મૂકી આપ્યો. ના સાહેબ, બિફોર ધી પ્રોસીડિંગ ઇનિશિયેટિવ
Yes.
વધુમાં તારીખના ભાડા કરાવવામાં 2 વખતે અમો સમાવેશ થઈ ગયો. પેલા જે લખી કરી નથી ને અમને લઈ એમ પેલું ભાડે આપેલ નથી. સો ધીસ આર ધ ટુ ડિફરન્ટ.
Yes.
Then sir, kindly see the rejoinder of the department dated 27th January 2011, page 51. It is 2 paragraph only.
Yes.
Kindly just see the paragraph 2. આ કામના ધણવાળા ભાડે રાખી મિલકત પ્રાય દિશની પેલા ભાડે આપે છે. અને ભાગીદાર દસ્તાવેજ ટેનેન્સી એગ્રીમેન્ટ તે સ્પષ્ટ તેમના ભાગીદારો જાણી હતી ને નજર હતી કે એનો કોઈ પુરાવા ધંધા કરવા માટે દસ્તાવેજ એ તદ્દન ખોટું ઊભું કરે છે. ટેનેન્સી રાઇટને ઉઠાવી થશે જે દસ્તાવેજ થવા પાત્ર અમારા તદ્દન મિલકત 44 પેટા ભાડે મૂકિત પુરાવા અને મિલકતમાં તારીખનો પાટનું નિધાન કરું ને પછી સાહેબ સર્ટિફિકેટ
Yes.
એના પછી સર પેજ 54 ઉપર 81/C.
Yes.
The details for PI stop and establishment license details. You
Yes.
must have employee detail, name. Sri Dinesh Chandra Kantilal, Ishwarbhai Mohanji Jingal. અને સાહેબ છેલ્લે પોસ્ટમાં એડ્રેસ પછી ડિપાર્ટમેન્ટ પાર્ટી.
Yes.
This also has been produced by the FM. Then sir, evidence has been filed. And before that, the page 83/C is already read before the court.
Yes.
Dated 24th August 2011.
Yes.
And then on 27th September 11, page 71, that's my evidence. Now the rating rules 4.
Yes.
I'm sorry, page 71. So this is somehow purpose of passing actually.
Yes.
Emma said, kindly turn to the paragraph 5. ચાર સુધી તો મારો WS જ છે.
Yes.
Then sir, paragraph 5 at page 4 of running page 4 of that my evidence. The first document which has been referred in paragraph 5, that's a deed of partnership.
Yes.
Then the notice reply,
Yes.
એના છે બીજા પેજ ઉપર. Then sir, kindly turn to paragraph 6
Yes.
on page 6.
Yes.
વધુમાં આ 113 ફંક્શનના લિસ્ટે મોડેલને દસ્તાવેજ છે. અમુક બધા નામનું એટલે કે અમે બદલ રાખવા માટે કરવાનું છે. જેનો અમે ધીરજ સાહેબનું નામ છે ધીરજનો ઉલ્લેખ દાળ વિકલ્પ સન્માન સદુપકરણ વખતે રેન્ડિંગ પણ કરવામાં આવે છે. હવે પાકો આ કાપશો 113/CT અમુક પ્રત્યે અમે નામે નાયબ પોલીસ કહેવામાં છે. અને ત્રીજું સાહેબ 113/C અમદાવાદ કોર્પોરેશન દ્વારા એસ્ટાબ્લિશમેન્ટનું સર્ટિફિકેટ છે. So these are the documents
Yes.
produced by the. Now, sir, to this there is no cross exam.
Yes.
And then, sir, the last but the least, so far as these pleadings are concerned, it comes up with
Yes.
page 66. मैं से एक જ પેરેગ્રાફ
न्यूज
kindly turn to paragraph 10. Page number 4.
यस
વધુમાં મારું નમ્રપણે કહેવું છે કે ગુજરાત પબ્લિક કલમ 4 મુજબ સ્ટેચ્યુટરી નોટિસ બધા જ ઓક્યુપાઈ આપવાની જોગવાઈ છે, જેમાં કલમ 4 પેટા કલમ 2 ક્લોઝ માં જેમાં તેથી પણ અગેન રખવાનું થાય. Sir, then kindly turn to the overlay page, paragraph 11.
यस વધુમાં
વધુમાં આ કામના ફરિયાદી તારીખના રોજ તેમણે એમાં જે નોટિસ મોકલી તેમાં કારણ દર્શાવવા સમય દઈને જણાવ્યું, જેથી સાતનું સમર્પણ કાયદાની કલમ 4 કલમ 2 પેટા કલમ 2 સોરી ક્લોઝ બી ની જોગવાઈ પ્રમાણે હતું તોય ભર્યા નોટિસ રખવાનું અને સાહેબ પછી હેન્ડ રિટર્ન છે.
यस
વધુમાં ફરિયાદે કોઈ મૌખિક પુરાવો આપેલ નથી. અમો સવાલ અમારી દસ્તાવેજ દ્વારા કદાચ તારીખના રોજ સતપાસ વિશે જેમાં ફરિયાદી કોઈ વિરોધ તપાસ કરેલો નથી. ફરિયાદે અમારો જો બચાવ ચેલેન્જ કરેલ નથી.
यस
Now, sir, કોર્ટના જે પ્રોસિડિંગ છે સર એમાં kindly see exhibit 18. During the pendency of the appeal,
यस
documents produced by the appellant. એમાં સાહેબ આ કરાર અરજી છે which has been allowed by this honorable court
यस
અને આ 19 એનું લિસ્ટ છે સર. અને નામદાર કોર્ટે ABCD અને માર્ક આપેલો. And it now just see the 4 letters. The first is 8 October 2009. After the eviction proceeding.
वन यस
Now, kindly just see the first letter 8 October 2009. Written by the respondent.
यस
ઉપરોક્ત વિષયના અનુસંધાને જણાવો એક સાત 99 ભાડું પ્રમાણે વધારા અંગેની સંદર્ભ મુજબના પત્રથી આપને જાણ કરવામાં આવે છે, જેના અનુસંધાને માન્ય ઉપપ્રમુખ પ્રકારે તમામ લઈ તરીકાનું નક્કી કરવાનું કારણ ભાડું વધારા સંમતિ આપવા જે લેખિત આ નથી જેના ભાડા ધોરણ મોકલી આપવા આપવાનું જાણ કરો કે આપણે ભાડા આપવું જોઈએ તથા નવા ભાડા આપવા સંમત નહીં આવતું પ્રશ્ન આવશે નહીં. ભાડા તે મુજબ આગળની કાર્ય નોંધ કરાવવી.
यस
And it turns to the next page, 26 October 2009.
यस
Later written by all the tenants, including the present applicant. નમસ્કાર, જય વિનંતી સર, જણાવું કે આપનું તો પીનારું હતું પત્ર ભાડા મળે તે બાદ જણાવું કે અમુક જે આપને કયા મુજબ વાસ્તે 3 ગણું ભાડું વધારી આપે તો હાલ આપને વિનંતી કોઈ જાતનું ભાડું વધારે મારી આપશું વિનંતી.
यस
સર kindly now see the Mark C
यस
14 જુલાઈ 2010.
यस
આથી ઉપરોક્ત વિષય જેમ પરની માલિકીના હાલમાં ભડવત પેટી ઉપલબ્ધ હતા. જિલ્લા પંચાયત ટેનામેન્ટ નંબર ત્યાં સુધી ભરાઈ બધાની પહોંચ નહોતું કે પત્ર મળે જોઈએ એમાં રજૂ કરશું.
यस
સાહેબ 18/8/2010 which is very important. The letter of the respondent ને
Yes.
એમને ઠરાવ મોકલેલો છે.
यस
ઉપરોક્ત વિષયના અનુસંધાને જણાવવાનું કે આપની સાથે થયેલ ચર્ચા મુજબ ભાડા વધારાનો ઠરાવ જિલ્લા પંચાયત અમદાવાદ તારીખ 30 જૂન 2010 ના રોજ મળે કારોબારી સમિતિમાં મૂકવામાં આવે છે, જે કામ ઠરાવ નંબર 64 થી મંજૂર કરવામાં આવે છે, જેની નકલ આ સાથે સામે છે, જે મુજબ નવું ભાડું અત્રે મોકલી આપવા કરાર સત્વરી કરવા નાના સામે. હવે સાહેબ એમાં એ જે ઠરાવ જોડે મોકલ્યો એની જસી દે ઠરાવ નંબર 64 ઇન્ટરનલ રનિંગ પેજ નંબર 3 સર.
यस
જિલ્લા પંચાયત અમદાવાદના મુખ્ય બિલ્ડિંગમાં હોય તો એ જિલ્લા પંચાયતે કુલ 11 શોરૂમ ઓછા ભાડે આપેલ છે. ઉક્ત ભાડું હતું સર નવું ભાડું એ ખાસ કારોબારી સમિતિની બેઠકમાં ઠરાવ નંબરથી મંજૂર કરવામાં મળેલ મંજૂરી અન્વયે દર વર્ષે આ તકલીફમાં ભાડા વધારો 3 વર્ષે 40% વધારો થાય સદા નવા ભાડા અમલ થી કરવામાં આવેલ છે અને તેની મુદત પૂરી થતી નવા ભાડા 8% જેથી 9 થી 9 બળી ગયેલ છે. આ તમામ ભાડો છે ચારે જેમ તે આપેલ છે તે નીચે તમામ ભાડો 2009 થી 2009 એક સાથ 9 સુધી બદલે 3 વર્ષ માટે ખંડતિકાનું ભાડું એક સાથથી ભરના થાય ત્યાં સુધી ભરણ પહેલું સમસ્યા આપેલ. સાહેબ જે ચાર્ટ છે પેજ નંબર 4 ઉપર
Yes.
એમાં સાહેબ આઈટમ નંબર 10 જો
Yes.
એટલા નંબર 1 દિનેશ કાંતિલાલ ઠક્કર which the appellant before the court.
Yes.
ઉપરોક્ત ભાડા ભાઈ મજૂર સર્વતે ધરાવવામાં આવે છે.
Yes.
પછી સાહેબ એક્ઝિબિટ 27 એમાં બીજા 4 ડોક્યુમેન્ટ રજૂ થયેલા.
Yes.
એક્ઝિબિટ 29 સાહેબ એમાં 4 ડોક્યુમેન્ટ.
Yes.
પહેલું સાહેબ જે સપોઝ નોટિસ 3 વીક્સ
Yes.
પહેલા મેં વાંચેલી. પછી સાહેબ જે બીજો જે ડોક્યુમેન્ટ છે ભાડું જે જમા કરે છે 5th May 2011.
Yes.
પછી સાહેબ ત્રીજો લેટર છે જે 16/7/2011 આજે ઉપરોક્ત વિષય જણાવવાનું કે જિલ્લા પંચાયતની માલિકીના વ્યાજમાં ભાડો ચૂકવણી કરતા જિલ્લા પંચાયતના કેનાવેલ નંબરની લિટર ત્યાંથી ભરપાઈ ભેગા બદલી પણ રજૂ કરશો છે. ને પછી સાહેબ ચોથો લેટર 5th December 2011
Yes.
એ ગટર કે એના માટે જે પ્રોબ્લેમ હતો
Yes.
એના લખેલું appellant લેટર છે.
Yes.
જે આપણે કહ્યું એના ઉપર જ્યારે જજમેન્ટ તો ફર્સ્ટ ઇઝ ધ બોમ્બે હાઈકોર્ટ year 1992 બોમ્બે page 6
Lock.
આપો
આમાં છે?
ના એમાં નથી હું આપું છું.
Yes.
So first kindly just see the paragraph number 5,
Yes.
section 4 and 5. Because instead of going to the statute, the
Yes.
section has been reproduced by the
Yes.
Honorable Court. Section 4 and 5 read as thus. Section 4, subsection 3, the section is of opinion. Any person, you want to just make note of the opinion,
Yes.
and this has been developed in the judgment itself.
Yes.
What is the significance of the word opinion used in the statute? Any persons are in authorized occupation of any public land, that they should be evicted, the estate shall. The estate officer shall issue in the manner herein after providing the notice in writing calling upon all persons concerned to show cause why order of eviction should not be made. The notice shall specify the grounds on which the order of eviction is proposed to be made.
Yes.
So therefore, the ground that the lease has come to an end is required to be made ground in the notice which contemplated under section 4, which is the mandate.
Yes.
Require all person, kindly just see the subsection.
Yes.
Require all person concerned, that is to say all person who are or maybe in occupation of or claim interest in the public premises. So it's covered both my legal submission which I made. That without issuing the notice of the court, these which has come together.
Yes.
The second, unauthorized occupant according to the respondent to whom they will not grant the notice.
Yes.
And then sir, subsection 4, on the same page, at the bottom of the page,
Yes.
where the estate officer knows or has reasons to believe that any persons are in occupation of the public premises, then without prejudice to the provision of subsection 2, he shall cause a copy of the notice to be served on every such person by post or by delivery or tendering to that person or in such manner as may be prescribed.
Yes.
Then sir, kindly turn to the stage paragraph 34.
Yes.
Page number 14. Sir.
Yes.
The provision of the Eviction Act can be applied to a person who are in unauthorized occupation of public property. A person by reason of section 2G is in unauthorized occupation if his occupation is without authority.
Yes.
He is an unauthorized occupant if he continues to occupy public property after the authority under which he was allowed to occupy the same has expired or has been determined by any reason whatsoever.
Yes.
The provision of the Eviction Act 19 therefore entitled the government, company or corporation which is the owner of the property to terminate for any reason whatsoever the authority of the occupant to occupy the same by so doing, place the government, company or corporate the occupant in the position of the landlord and the tenant government the provision of the transfer of property. The provision section 4 and 5 of the Eviction Act deal with the procedure for the eviction of another occupant must be read together. Section 4 prescribes that the unauthorized occupant must be issued with a notice in writing to show cause.
Yes.
Why an order of eviction should not be passed? Again, that notice has to be issued by the estate of provided. He is obvious that the addressee of the notice is on. And then the prima facie satisfaction must be twofold.
Yes.
Firstly, that the addressee is in unauthorized occupation of the building. Secondly, that he should be evicted. The notice must set out the grounds on which the order of eviction proposed to be made. It must therefore state on not only why the addressee is sought to be unauthorized occupant, but also why he sought to be thought that he should be evicted. It must inform the addressee that he is entitled to show cause against the proposed order of eviction. The addressee cannot effectively show cause unless he knows why the estate officer is of the opinion that he is in unauthorized occupation. He also cannot show effective cause unless he knows why his eviction is proposed.
Yes.
The provision of section 4 make it clear that the addressee makes personal hearing from the estate officer and may lead evidence for the purposes of showing cause against the proposed order of eviction. This is clear also from the provision of section 8, which vests in the estate officer the power of civil and production of documents.
Yes.
Then paragraph 35.
Yes.
Under section 5, the estate officer must consider the cause that is shown by the addressee. Plainly, he must consider the addressee case on both grounds. That is, whether he is in authorized occupation or public premises, whether he should be evicted. Even if he finds that the addressee authorized occupant, the estate officer is not obliged to make an order of eviction. He may make it. It is therefore that he has to consider the addressee should be evicted. He is obliged if he makes an order of eviction to record his reason. The estate officer must therefore state why he is satisfied with the addressee's unauthorized occupation of premises and why he should be evicted therefrom. The validity of the conclusion would be tested in appeal, which is before a district judge or actually which I am doing.
Yes.
Then, sir, kindly turn to the paragraph 37. We cannot accept Mr. Silvai's submission with towering personality that in so construing section 4 and 5, we would be reading them down or reading moves into them. We read them as they stand. Now are we reading the standards laid down in the so and so into section 4 and 5? These cases set out the norms by which the action of the government company corporate in respect of their parents have to be judged. Government companies and also accordingly. It was Silvai's submission that the action conferred unfettered power and There was a challenge between the rented and the
Yes.
that conflict, and so therefore this judgment is reviewed by the Honorable Bombay. It's at paragraph 38, the last
Yes.
couple of lines, instead of the reading from the top of the page.
Yes.
Section 4, calling upon him to show us why it should not be evicted, where to plead that he was not in occupation. It become necessary for the SO to require whether such a plea was valid. But if we did not dispute that he had become an unauthorized occupant, or having raised a dispute failed to prove that he was not an unauthorized occupant, the estate officer was empowered to pass an order. The jurisdiction of the estate officer, section 5 was 22. He is satisfied as to the unauthorized occupation. The person concerned is not about the bona fide requirement of the public choose, because that was the ground in the judgment which is
Yes.
I'm referring. Then, sir, paragraph 39 on the next page. With great respect to the learned judges of the Karnataka, we are unable to agree. The judgment takes into account section 4. In our view, it is imperative that section 4 and 5 read together harmoniously, and further no account is taken of the use of the word may in section 5. Thereunder, even if the established is satisfied that the public remains an unauthorized occupation, he may make an order of eviction. The judgment does not hold that the word may should be construed to be same. We have stated above that when section 4 are read together and anonymously, it becomes clear that the word may in section 5 does not mean by may that though the estimate may be satisfied that the public may not follow. He is not obliged to make an order. We are also unable to accept Mr. Sivai's submission that section 5, who does not contemplate two preconditions to the issuance of the supervision. That the only precondition is the opinion of the estate that a person whom the address is that the notice of the nor can we accept the submission that the word has to be read into section 4. That is to say that it has to be read so if the asset officer is the opinion that any person are in a location of inference, therefore they should be reached. The same issue, as we have stated, the asset officer must therefore issue the notice under section 4, be of opinion that the persons are in a recognizing that they should be reached. Now, so that notice is missing in the place. Before the opinion given by the estate officer, they filed the eviction petition application. Relying upon them, he has given the focus. It is significant. It is significant that the words and that the emphasize about have been used and not just the word "and." They leave us in doubt that the estate officer must have formed the opinion both on counts before he issues the notice.
Yes.
Which squarely missing in the present case. Then, sir, 41. Support made to be drawn from the judgment of the before commencing any inquiry on the occupation. A state officer is required to form an opinion that there are persons in unauthorized occupation of such premises that it is necessary that should be evicted from the premises unauthorizedly occupied by them. There is thus an indication of such in section 4 that the tribunal constituent of the act has to be form an opinion in respect of the matters to be decided finally by after giving opportunity to show cause and recording evidence.
Yes.
Then, sir, paragraph 42.
Yes.
It is important to note that the division bench was of the view that the estate officer had finally decided under section 5 matters in respect of which he had initially formed an opinion under section 4 that there are persons authorized occupant, therefore the support. 43 is more relevant.
Yes.
Reference was made by Mr. to the judgment of Calcutta. In this judgment was held by special bench of the judgment. All the subsection 2, section 4 required was that the notice under subsection 1 should specify the grounds on which order of eviction proposed to be made. If notice to quit had been validly served, the period specified therein will be required, then the person served was entitled. This was sufficient ground for an order of eviction. So there is a mandate as per the judgment of, and second judgment which I have the reliance of the honorable student. There also the same dictate which has been passed by the Bombay.
Yes.
The person concerned had no defense because the West Bengal criminal did not apply to the regime. Then, sir, So the two things for which I just wanted the court with his judgment of the honorable
Yes.
state. Before he issued the notice under section 4, he has to form his opinion.
Yes.
Then number 2 legal proposition is that all the unauthorized occupant, according to the opinion of the estate officer, is supposed to require to issue the notice and serve upon him.
Yes.
Then, sir, now the second judgment of the Honorable Supreme Court. 2008 Supreme Court, page 876. First, sir, kindly just see paragraph 2.
Yes.
Who should begin to lead evidence in a proceeding under the public premise? Is the question involving these appeals. Then,
Yes.
sir, kindly turn to paragraph 7. Upon an application filed by the appellant, the estate officer by an order dated 26 August directed the first respondent to lead evidence, wherein his affidavit was directed to file an affidavit of evidence. The matter was adjourned to for cross-examination of the person by the appellant's advocate. First respondent now filed an application before the estate officer, praying inter alia that he should vary his order dated so and so and direct the appellant to read his evidence first and offer his witnesses for calling of other person respondent. Thereafter, he would find his affidavit of evidence. The state application was rejected by the state. Then, sir, paragraph 9.
Yes.
Before the estate officer, the appellant filed his affidavit of evidence. Dates after dates were fixed for cross-examination of the witnesses. Were fixed for cross-examination of the witnesses of the appellant. Appellant had been taking adjournment in the matter. And on about so and so, the appellate party be directed to show person. Then paragraph 10 sir, on the same page.
Yes.
By order dated, so the estate officer directed the first respondent to read evidence by following up. Both application disposed of applicant dated so and so, the office by department out. As regard application dated so and so taken out by the applicants, I direct the opposite party to find that approval and details of this in lieu of evidence in chief honor before so and so complete dispute of if any, in extend the matter so and so. Then, sir, paragraph 13D, where the giant of the where he was, Mr. Nariman, make this legal submission.
Yes.
Paragraph 13, only the D is relevant.
Yes.
A party to the lease cannot ordinarily be directed to prove a negative. In that view of the matter, if we for the insurance company to read evidence of first things.
Mm.
Sir, our case, in their case, there was a subletting.
Yes.
I am not required to prove can a subletting nothing negative.
Yes.
Positive, they required to prove.
Yes.
Therefore, I read D, the legal submission of the recorded in paragraph 13. Then, sir, paragraph 17.
Yes.
Section 3 of the Act provides for appointment. Section 4 issued notice, the same was the Bombay
Yes, yes.
Bombay Code. Issued notice to opine that any person or occupation specified the notice shall present the grounds. Then, sir, paragraph 20, where the rule has been discussed by
Yes.
Honorable Supreme Court. Rules
Yes.
have been framed by the central government in exercise of all this power under section 18, known as the public demands, which is material for these appeals, read as under holding of inquiries. Where any person, sir, I must clarify before this part.
Yes.
This judgment of the Honorable Supreme Court deals with the central law,
Yes.
public premise.
Yes.
Whereas in our state, there is a local, the state legislation is also there. એ સાહેબ મેં બાઇન્ડ કરીને એક આપેલું છે ને,
Yes.
જેનું ટાઇટલ છે કે ગુજરાત પબ્લિક પ્રિમાઇસ ઇલેક્શન ઓફ અનઓર્ગનાઇઝ્ડ ઓક્યુપાઇડ એક્ટ 1970. ને એમાં સાહેબ રૂલ્સ ફ્રેમ નથી થાય.
Yes.
રૂલ્સ છે પણ જે સાહેબ રૂલ 5 જે સેન્ટ્રલમાં છે
Yes.
એ સાહેબ સ્ટેટ લેજિસ્લેશનમાં રૂલ્સમાં એ
Yes. Yes.
Just I on the paragraph 20 of the judgment of the Honorable Supreme Court. In page 7. Holding of inquiries, where any person on whom a notice under this act has been served desires to be heard through his representative should authorize the between writing. The estate office shall record the summary of such evidence. And then, sir, paragraph 24. Where an application is filed for eviction of another occupant, it obliges the estate office to apply his mind so as to enable him to form an opinion that the extent is a person who has been authorized occupant of the public domain that it should be evicted. When a notice is issued in terms of section 4 of the Act, the notice may show cause, section 5 that was triggered, which we are aware of the section 5. Then, sir, paragraph 30. Where an application for eviction is based on such grounds. Need to read paragraph.
Yes.
Page,
Yes.
Where an application of eviction is based on such grounds, which require production of positive evidence on the part of the landlord. In our opinion, it would be permit to adduce
For
evidence
it.
first.
For it.
For it, I'm obliged, sir. It would be for it to adduce evidence first, more so in a composite application where the evidence is also required to be in the quantum of damages, which are not concerned.
Damage.
Then, sir, paragraph 33 on the same page. The
Yes.
estate officer, with a view to determine the lease between the parties, must record summary of the evidence. Summary of the evidence and the document shall also form part of the record of the proceeding. Procedure laid down for recording evidence is stated in the rules. The estate officer, being a creator of the statute, must comply the same. When a notice issued, the occupant of the units would not only be entitled to show cause, but would also entitled to produce evidence in support of his case also. Then, sir, paragraph 38.
Yes.
It is very important, sir.
Yes.
The statute, although does not require a lengthy hearing or a lengthy cross-examination, but the notice should be given an opportunity to file an effective show cause. An effective show cause can file when eviction is sought for a specified ground. The occupant must know the particulars and realize that.
Yes.
39, sir. For the same purpose, section 4 and 5 must be read together, even the rules which are very different must be read together. Read along with the statutory provision ordinarily, although a tenant occupying the property belonging to the government may be somewhat in a worse position than a tenant having protection under the Rent Control Act, as has been laid by the full bench. But with a view to interpret the provision of the Act, we must take into consideration the reason of this got pinned down, the concept bona fide act, and the fair action on the part of the owner is laid down. And then, sir, paragraph 44 and 48.
Yes.
Acts of justice.
Yes.
If some facts are to be proved by the landlord, indisputably the occupant should get an opportunity to cross-examine, which is
Yes.
missing in the present case.
Yes.
The witness who intends to prove the said fact has the right to cross-examine.
Yes.
This may not be provided by under the statute, but it being a part of the principle of nature justice. Sir, may I have with all fairness,
Yes.
state legislation ma rules ma side J5,
Yes.
central ma nothing, but this is what the Honorable Supreme Court has said.
Yes.
Leave aside the statute.
Yes.
Principle of nature justice commands and requires, which recorded in paragraph 40.
Yes.
It being a part of the principle of nature justice should be held to be indefeasible right. Then 45. Sir.
Yes.
We may also take note of the fact that this court in so and so this was a late under. The application of the principle of nature does not imply that what is not evidence can be acted upon. On the other hand, what it makes is that no material can be relied upon to establish a contested fact which are not spoken to by a person who are competent to speak about them and are subjected to the government by the party against them. They are sought to be issued.
Yes.
Such appellant has created third party rights by transferring the property. It's a spoken words
Yes.
missing in the present case.
Yes.
It is axiomatic of that when in support of his case, the landlord intends to rely upon a document which has to be taken on record it would be obligatory on the part of the estate officer to allow inspection. Notice denial of such inspection documentation provided. We will also notice the main of this code having regard to the fact that burden of proof was on the notice statute of a status of a person. I'm sorry.
Yes.
Status of a person, however, is determined according to statute. The Evidence Act of our country has made provision as regards burden of proof. Different statute also lay down as to how and in what manner burden is to be discharged. Even some penal statute contain provision that burden of proof shall be on the accused only because burden of proof under certain situation is placed on the accused. The same would not mean that he is deprived of the procedural safeguard.
Yes.
It was observed in regard to the fact that tribunal in the notice to be sent to the previous, it required to be set out the main grounds. Evidently, the primary owners in relation to that, and then imputed approval. Section 5 of the on a plain reading. On a plain reading would place the entire owners upon a notice. If in no uncertain terms state that the once a notice under such issued by the owner on formation of its opinions and hearing this for the notice. Notice is not only to show cause thereof, but also adduce the evidence and make out the rules. Literal meaning in situation of this nature would lead to a conclusion that the landlord is not adduce any evidence at all required even to make any oral submission. Such a literal construction would lead to an anonymous situation because the landlord may not be heard at all. It may not even be permitted to adduce an evidence rebuttal to one of adduced by the notice or would be permitted to evidence an argument. Is this contemporary law? The answer must be rendered in the negative.
Yeah.
When a landlord finds an application, it in a given situation must able to read evidence either the first instance or after the date by the notice to start this case or if it is referred. Then, sir, paragraph 54. Conclusion.
Yes. 54.
No, 52. Although the provision of the evidence are not applicable, the underlying principle of section 101 thereof would apply in Sarkar, so it's principle and scope. This section is based on the rule that is incumbent provision, the burden of proving a fact based on the party who substantially assert the affirmative of the issue and not upon the party who denies it, or a negative is usually incapable of proof. It is an ancient rule of founded on consideration of good sense and should not be departed from without strong reason. This rule is derived from the Roman law and is supportable not only upon the ground of evidence, but also upon that of the greater practical difficulty, which is involved in proving the negative, then in proving an affirmative.
Yes.
And then paragraph 56, sir. We, however, must not shut our eyes to the object for which the act was enacted. It provided for a speedy remedy. The estate officer is expected to arrive at a decision as quickly as possible. The provision of the court in evidence not being applied. What is necessary to be complied with is the principle of nature justice.
Yes.
Then, sir, last but the least, paragraph 15 on the last page. We therefore, this is the conclusion of the
Yes.
Supreme Court. We therefore direct both the parties must file the documents within a week from today. The estate must be both the parties' inspection of the trade. The appellant must find the affidavit witnesses within 2 weeks, and thus appellants having the insurance company shall be produced for government within 1 week thereafter. In appeal arising, the witnesses must be produced for government as is possible, but not due to. So the conclusion of this judgment, which are just place reliance and laid before the court.
Yes.
3 things. Irrespective of the fact that whether there is a provision in the rules or the statute, but
Yes.
on the ground of the principle of nature justice, ABC. Second, the negative doesn't require to prove. So therefore, meaning thereby, if it is the case or the case contended by the appellant, the respondent authority, that the appellant has subletted the premises, it is to whom they have to prove positivity, which they have not done. They have not laid the oral evidence. They may not make available for cross examination any witnesses to the appellant.
No oral evidence.
No oral evidence. અને સાહેબ મારા એવિડન્સ પછીથી they file only the rejoinder,
Yes.
so not the spoken words,
Yes.
as per the judgment of the Honorable Supreme.
Yes, Mr.
Now, sir, there are સાહેબ જે બર્ડન જે આજે પાર્ટનરશિપ નું જે છે
Yes.
input my case એમાં સાહેબ 3 જજમેન્ટ છે. સોરી બે છે.
Yes. Yes.
એક જ મિનિટ. First is power of the expertise.
Yes.
એમાં સાહેબ પેરેગ્રાફ 3 અને 5 that this is not public premises પણ સાહેબ જે પ્રિન્સિપલ ઇશ્યુ ઇન્વોલ્વ થયેલો છે સાહેબ
Yes.
ભાગીદારી કરીને એટલે સાહેબ these
Yes.
are just to assist the court I
Yes.
am relying
Para?
on paragraph 3 sir.
3.
The facts are not in dispute. The tenant was carrying on business in the demised premises on his own as the sole proprietor of the business. In October, the tenant took in defend number 2 and defend number 3 as a partner from the onwards. The tenant developed this pursuit to partners carrying business. This is facts involving the judgment.
Yes.
Then sir, paragraph 5 on the next page. Whether or not it will constitute subletting may now be examined.
Yes.
Subletting constitutes two distinct persons, the head tenant and the subtenant. Their rights and obligations are different. One cannot be one's own subtenant. If the transaction of taking partners constitutes a subletting, the defendant tenant will be head tenant and he himself along with his two partners will be the subtenant. It is not necessary to uncover the fallacy in this trade by reasoning any further, as it is not feasible to accede to the argument that the partners of a firm constitute a legal entity having a distinct identity or personality. It is not possible to hold that a transfer has taken place from the tenant to himself or two others, his partners. The contention cannot therefore be upheld. The subtenant has come into existence between the tenant and his partner on the other ground as well. So this is what the High Court has said.
Yes.
Then, sir, the second judgment of the Honorable Supreme Court. Citation to year 1986, Supreme Court. Page 156. 86, Supreme Court, page 156. હમણાં આફિસ છે ઝેરોક્સ મળી જશે. સર આમાં પેરેગ્રાફ 3, 5 અને 8. So this is the larger bench judgment.
Yes.
This as I submitted, it is from the rent court, the rent controller.
Yes.
Paragraph 3, sir, we have been taken through the judgments of the rent control and the rent control tribunal. We have also been taken through the relevant evidence. The facts which emerges from the evidence are that the garment goods carrier and others is paragraph 3, factual data,
Yes.
matrix of the change, then paragraph 5, sir. In the first case, the facts were that a shop was let out owing to a certain firm. The business of the partner was closed before. Thereafter, a new firm consisting of an elsewhere partner with the loan firm. Strangers started doing business on the same. The question arose whether in this it is said that there was completing the content that the old form and the new form convocation. And I said, man, second bay paragraph छोड़ेंगे. The question what was received to do when subletting was ready was then considered it was said.
Yes.
It seems to us that the landlord cannot succeed. He has to prove it as a fact that there was a subletting by his tenant to another person. He does not prove this merely by showing that his tenant was one form, the premises are in the occupation of another form. As is sought to be done in the present case. Mere possession by somebody other than the tenant would not necessarily prove that the premises had been sublet by some case
Yes.
they relied upon the Panchnama.
Yes.
ને પંચનામામાં એમને એમ કહ્યું કે આ જે સબટેનન્ટ છે અમે કહીએ છીએ એ ત્યાં બેઠેલા છે હું ટેનન્ટ નહીં.
Yes.
This is their case, sir. રેકોર્ડ ઉપર નથી પણ સાહેબ એવું એટલે રિટર્નમાં કહ્યું.
Yes.
Therefore, I am reading this paragraph. It is admitted that there is no evidence in this case to prove the fact of subletting. This case in particular, we continue in possession of one of the original tenants. It may be, as the learned counsel of the appellant said, attention of the courts below had not been directed to the fact in issues, namely the proof of subletting. If that was so, that the fault was that of this client, the landlord. He cannot now claim any relief on that ground. As we have said, admitted that the evidence does not accept there was any subletting of by the tenant. There was nothing to prevent the landlord from leading evidence to establish that it was, if it is was a fact, if he has misconducted his case, as he says, he must take the consequence.
Yes.
Just at the last but the least of the judgment. Paragraph number 8.
Yes.
As mentioned by us earlier, so court is not accepted.
Yes.
In the last judgment, sir, the Honorable Supreme Court, which has gone to our High Court. Remember paragraph first 3. First, I'll just with the view of the court, read the
Yeah.
record.
Yeah.
Subletting.
Yes.
Business of partnership was carried on in premises of which one partner was letting, where there was no subletting. It's
Yes.
well settled that if there was partnership firm of which tenant of the place in which the business of the firm was carried on with the partner, the fact of earning of business should not amount to subletting. Then
Yes.
the state go to the paragraph 3.
Yes.
It's a factual matrix.
Yes.
I will not bother the court. But name of the Ahmedabad finance
Yes.
first.
Yes.
Give the efforts in my time. Then sir, paragraph 5. The main question in issuing this appeal as well as before the High Court in division was whether there was a genuine partnership at all in which the appellant was partner. It is true that since the part firm was carrying on business, the previous question, certain amount with the appellant was partner, would not amount to subletting leading to the purchase of the tenants. For this purpose, the decision of the Gujarat High Court, so it's so and so.
Yes.
Then, sir, paragraph 8. So this is the leading case so far as this issue is concerned.
Yes.
The gone from the our High Court.
Yes.
Whether there was a partnership or not, may in certain cases be a big question of law and fact. In the sense that whether the ingredients of the partnership that may embodied in the law of partnership where or not in a particular case or not, must be judged in the light of the principle of applicable partnership. The first question therefore is what is partnership? That has to be found section 4. And I said section
Yes. Yes.
they will discuss a lot of things.
Yes.
Which I am not bothered with. Then sir, kindly turn to the paragraph 12.
Yes.
Then paragraph 13, the question is, can the High Court do so in law? The power of the High Court to revise the order of containing section so and so, which will read as under. And then the last paragraph 19. In a look at the basic question whether keeping like deeds refer to here about even before the fact that came to light was there or not. Sharing of profits, contributing to losses were not the only elements in a partner. The existence of the agency was essential whether there was a partner or not in the section of law. In fact, depending upon the various cases, these views are dictated by the Chief Justice in so that whether the relation partner or not does or does not exist must depend upon the real intention and contract of the party, not the express intention. He has referred to section 4 about the principle of patent gain. So the court of legal considered this principle, elevated the evidence and narrated that there was in fact in law partnership such a view was not impossible. One or reverse perverse one. If that was so, there was nothing that could be done about such a view within the admitted scope of our so as the learned Chief Justice then was held that there cannot be subletting unless this lessee parted with the legal possession. The mere fact that another is allowed to use the premise while the lessee remains the legal possession, not enough to create a surplus. So kindly apply this test,
Yes.
which are just relied upon the three judgments.
Yes.
Fortunately, all of them are of the own one item,
You have to.
which lead to the conclusion in this case.
Yes, legal position. Yes.
At the first instance, they are not laid the oral evidence. So therefore, they are not discharged the burden.
One. Yes.
Therefore, the order passed by the
Yes.
tested officer reserves the caution certificate.
Yes.
I may just make a point that while during the pendency of this appeal,
Yes.
the honor in the sense this honorable court is protected by that, and the order has been passed on the statement.
Statement.
They made the statement. I'm obliged. But I believe, sir, जे आपे कर
2-3. 2-3-19.
Sorry?
2-3-19.
Correct,
Order below exhibit 31-33.
sir, I'm obliged. Where the statement made across the bar has been recorded.
Yes. Would not demolish the property. Yes. Yes, Mr.
Yes, sir.
એ તમે નથી સલોટ
Follow, sir.
તો તમે કોણ છો?
હું એમનો junior. તો શનિવારની તારીખ આપતો
કયા શનિવારની આવતા? કાલે શનિવાર છે.
કાલે